LLB subject summaries, Constitutional Law 1, Articles 1 to 51A under Part 4A is the topic for discussion today in English language. This topic, Constitutional Law 1 summary, was uploaded 2 days back in Telugu language. Today I am uploading this topic, this summary in English language. This Constitutional Law 1 I will upload in 3 parts. Part 1, Constitutional Law 1 contains preliminary concepts and contents in brief. And in second lecture, I will take up preliminary concepts, namely constitutional law meaning, kinds, features, historical background, features, federal features, and preamble. These preliminary topics are very important from examination and knowledge point of view. One who will have very good idea about these preliminary concepts, historical background, salient features of the Indian Constitution, federal features, nature of Indian Constitution, whether federal or unitary or quasi-federal, and preamble, what are the ideals and goals to be achieved through Constitution, are very important, not only from knowledge point of view but also from examination point of view. And this lecture, the contents of Article 1 to 51 plus preliminary concepts in brief I will cover. In second lecture, I will take up preliminary concepts, namely meaning of Constitution, kinds of Constitution, features, federalism, and preamble. Second class, in second lecture, I will explain it in not only in Telugu but also in English. In third phase, I will explain fundamental rights and directive principles in brief. To the best of my knowledge, I will enlighten you various aspects of the subject, dear friends. So, if you concentrate these 3 lectures for Telugu students, students of Andhra and Telangana, both in Telugu and English, and make note of important points in short notes with side headings and underlines, you will be able to manage in the examinations. Competitive exam people after this, and I have uploaded in English language Constitutional Law 1 almost all topics long back, but I did not upload them in Telugu. That's why I have started to upload not only in Telugu but also in English with latest developments and updated knowledge which I have acquired in the recent past. And third lecture, I will explain you in detail to the best of my ability fundamental rights and directive principles. This subject, constitutional law, was only one subject since from the beginning till the academic year 1999 and 2000. In that particular academic year 1999 and 2000, some subjects, namely criminal, constitutional law, labor law, and some other branches were split into 2 parts. Towards this direction, constitutional law is being taught in 2 papers. Constitutional Law 1 from preliminary concepts plus Article 1 to 51A in Constitutional Law 1. though the number of articles are limited, parts are limited, but the subject is voluminous. Please note it. And from in constitutional law 2, from part 5 to end of the part 25, all the topics will be taught in constitutional law 2. Dear friends, I uploaded constitutional law 2, so many important topics from examination point of view, not only in Telugu language but also in English language. So there is no need to upload in Telugu language once again, so far as constitutional law 2 is concerned, and very few topics were left. I will take up at the convenience. So now I have covered more than 18 subjects, but there are about 25 subjects. Some of them are enactments like Domestic Violence Act, Dowry Prohibition Act, Negotiable Instrument Act, like that. Small enactments are there, Consumer Protection Act, Motor Vehicles Act, like that. But in spite of that, I will take up all the topics, summaries, so that basing on the summary, the student will be able to go through some standard textbook. He can have some preliminary idea. Dear friends, if you refer any standard textbook like Jain Pandey, V.D. Mahajan, like that, in the beginning, you will find 4 preliminary concepts: meaning, definition, and kinds, historical background, salient features, federal features, and preamble. Thereafter, part 1 containing 4 articles will start. So in this way, as for this syllabus, what are the topics we are going to learn, I will explain you in brief. And then so this constitutional law is of great importance. I will take up some special class called corpus juris, that is the systematic classification of laws. There are various branches of law. For practical point of view, I will let you know what is public international law, what is private international law, what is national law or domestic law or municipal law or constitutional law, what is administrative law, what is law of crimes, formerly IPC, CRPC, today BNS, Bharatiya Nyaya Sanhita, and Bharatiya Suraksha, BNSS, Bharatiya Nyaya Suraksha Sanhita, like that. Then what are the substantive laws, what are the procedural laws, what are the special laws, all these aspects I will let you know in the very beginning. Dear friends, I sincerely and honestly tell you, I am taking untiring efforts to present before you the wonderful knowledge to the best of my ability and knowledge. Not only the LLB students, but also those who completed LLB and those appearing for judicial service exam, junior advocates, in particular the teachers who joined as started their teaching career, are given any subject to teach, 2 or 3 subjects if they are asked to teach. If they watch my channel first, that particular subject, and then read my book, and then thereafter if they read any standard books, they will be able to come up as a good talented teacher, is what I will be able to assure you, dear friends. So now coming to the constitutional law one. Actually, what is the historical background, I will tell you. This constitutional, among all branches of law, constitutional law is of great importance, great significance. The constitutional law is law of all laws in the country, because any law must be according to constitutional law, that is according to the provisions of the constitutional law. But constitutional law can never be according to any law. Even before the birth of constitutional law, that is before 1950, what were laws that were in force, but were in force there were thousands of laws that but were in force. In Third Law Commission, 19 legislations were passed by the British Parliament. From that Third Law Commission to emergence of from the existence of Indian Constitution, many more laws were passed, many more legislations were passed. In spite of that, according to Article 13, Clause 1 of the Indian Constitution, whatever laws were there before Indian Constitution came into force, those laws must be according to the provisions of law. If any pre-constitutional law, that is before the that is prior to 1950, what are the law? If any law is there, if any single provision or section or part, clause, anything is not according to provisions of the constitutional law, that is inconsistent, contrary or conflict with constitutional law, that law as a whole or that law in part or that particular part was to be declared void or unconstitutional. In Article 13, I will explain in detail. So, according to Article 13(1), whatever laws were there before Indian Constitution must be according to constitutional law. But after Indian Constitution came into force, that is from 26 January 1950, whatever law is passed, it must be in strict compliance, strict adherence to the provisions of the constitutional law. Otherwise, the post-constitutional law will be declared void or unconstitutional. That is why we can say that constitutional law is supreme law of the land. It is law of the land. It is the leader of laws in India. So, constitutional law is of such a great importance. So, in historical background, I will tell you, dear friends, what are the developments. There are 20 significant developments that took place for emergence of the Indian Constitution. It is not possible to explain all the 20 significant developments. I will explain in brief the basis or foundation for the emergence of constitutional law in next lecture, that is preliminary concepts. I will explain all these things. Actually, this constitutional law today, at the time of this constitutional law, it contained 395 articles, 22 parts and 8 schedules. So, after so many constitutional amendments, there are about 106 amendments have been passed into law. And whereas there are the latest amendment bill is pending before Parliament is 130 amendment bill. 130 amendment bill. So, up to 106 the bills were passed. The latest 106 bill is Nari Shakti Vandan Abhinayam. Women's Reservation Bill was passed by both houses of the Parliament and was referred to the state legislatures for ratification. This process will be completed for next general elections of Assembly, Lok Sabha elections. It will be this Nari Shakti Bill envisages 1/3 reservation, including reservation categories of SC, STs, etc. Suppose 300 seats are there, 100 seats should be given to ladies, women candidates, not only in state assemblies but also MLA elections, but also in Lok Sabha elections, MP elections. This bill, once this this act will come into force, then in next general elections onwards, the 1/3 will be women candidates. Other is general. A man may contest, woman may contest, whomsoever may contest, and accordingly the strength will be more than 130 from women representation. So now this is what is called. So I told you this. I told you, dear friend, and by the time Indian Constitution came into force on 26 January 1950, 1950, there were 395 articles, 22 parts, and 8 schedules. Today, we have 448 articles, 25 parts, and 12 schedules. So, technically, in any constitutional law, Bare Act, the number of sections will appear as 395 as the lot article. Dear friend, don't think whether article or section. Some legislations sections are used in some some constitution. Articles are used in some international conferences. The articles are used, but practically speaking, article and section is one and the same. Before Constitution came into force, the Government of India Act 1935 was treated as a constitution, for India and Pakistan. This in historical background, Bangladesh also. Bangladesh was a part and by the time UK declared. Britishers declared independence. India, two dominions, India and Pakistan. At that time, East Pakistan was comprised of Bangladesh. After civil liberation war, Bangladesh became independent in 1971. Then the Prime Minister of India, Mrs. Indira Gandhi, extended lot of support to the Bangladesh people. So all these aspects I will tell you in historical background. So some of you are the entrants, you may have doubt what is the article or section. Almost both are same so far as practical purpose is concerned. So there is slight difference between what article and section. I will tell you later. So in suppose just like some villages become one panchayat, one taluk. Some small villages, towns become one taluk. Some taluks become one district. Some districts become one state. Some states become one country. Like that. Some articles put together, it becomes one chapter. Some chapters put together, it becomes one part. Some parts put together, it becomes a constitution, subject as a whole body of law. So like this, in constitutional law, there are 448 articles. So 395 are article numbers, but there are so many acts, 323A, 323B, like that, 21A. So many ABCDs will be there, because the ABCDs are there in the sense subsequently Constitution was amended, and by through amendment acts the number of sections or number of articles are added. Not only the Constitution, but also so many legislations were amended subsequently. Dear friend, what is that amendment? What is that constitution? If the particular branch of law is arranged under sections, subsections, clauses, it is called that particular law is codified. Indian Contract Act, Indian Evidence Act, Transfer of Property Act, Hindu Marriage Act, Hindu Adoption and Maintenance Act, etc. So the rules and regulations relating to that particular branch of law are systematically arranged in parts, sections, subsections, like that. So then we say that particular branch of law is codified. Some branches of law are not codified. For example, administrative law. Administrative law is not codified. Environmental law is not codified, because there are more than 200 legislations applied in Indian environmental law, but as a whole there is the environmental law is not codified. Law of torts is there. Law of torts is not codified. Because there may be piecemeal legislations, they are all applied for law of torts litigation. But for example, Motor Vehicles Act, Consumer Protection Act, Carriers Act, like that. So many piecemeal legislation may be taken use of for this contracts, but there is no. So what is the main legislation? What is special legislation? All these aspects I will enlighten you in corpus juris, that is systematic classification of law. I will explain. So here, like this, the constitutional law is codified. So by the time the number of articles are one article 1 to 395, but when once amendment is there, but in constitution there are so many, constitution is authority, it directs to do this or that, the parliament is given, is vested with so power, with the power to pass so many laws or legislation by respective provision. For example, Article 323A gives power to Parliament to pass Administrative Tribunals Act 1985. Similarly, Article 14, Article 4 of the Indian Constitution gives power to Parliament to take any pass any law in order to make any changes under Article 2 or Article 3. Article 2 by it speaks that the power of the Parliament, the Article 2 speaks about acquisition of territory, acquisition of states and territory, that is. So Article 3 speaks about to make a state bigger or make a state smaller, to take a part of one state and take another part of another state and club these two parts and make it as an independent state. All these aspects are dealt with under Article 3. Like that, in order to make any changes with regard to Article 2 and Article 3 with regarding to increasing and decreasing acquisition and disposal of any state, the Parliament is given power. To that effect, for in order to take up these two powers, any amendments are to be made. Article 4 gives Parliament to pass any particular law with regard to bring about any changes in Article 2 and 3 of the Indian Constitution. Everywhere there are, incidentally, we come across so many articles that those articles give power to Parliament. Under that particular article, Parliament passes any legislation to bring out. Under this, the Parliament can pass, constitute any legislations. Under that, the Parliament can establish so many authorities. These aspects we will discuss in detail in course of time. Dear friend, that is why this is what is called, these are articles. So take it by number, we have 395 articles, but in practice there are many more articles, A, B, C, D, etc. If you take any bare act and apart from 395, if you collect the additional articles of A, B, C, D, and when you find, then the total count comes to 448. These 448 are divided into 22 parts at the time of beginning, because after constitutional amendments, new parts were passed. For example, constitutional amendment part 4, earlier part 4 was there, then subsequent amendment part 4A, fundamental duties, was created. Like that, 28, there are so many parts were passed by constitutional amendment. So that is why the number of parts increased from 22 to 25. By the time constitution came into force, there were 8 schedules only, but today there are 12 schedules. Why? Because schedule, what do you mean by schedule? Every act or enactment or legislation, after that there will be like appendix. We in so many textbooks we see appendix, list of cases or list of subject index, cases index, pro forma of application, for like this. So if you take this CRPC, and there will be 2 schedules. In one schedule there are tables, bailable offences, non-bailable offences, non-bailable offences, cognizable cognizable offences, non-cognizable offences, summons cases, warrant cases, like this. In Schedule 2, how the FIR pro forma will be there, how charge sheet pro forma will there, how affidavit pro forma will there, all these different forms are there. So that is it. If you take the Copyrights Act, how the agreement between author and publisher should be, it will be there. So like this, so these schedules will contain. Like that, in Indian Constitution, there are so many earlier, by the time Constitution came into force, there were only 8 schedules. Today there are 12 schedules. There are 12 schedules. So what are these schedules? I will explain in detail at the time of this. So for example, Schedule 1 tells you how many states are there in India, how many states are there in India, how many union territories. The list of states and union territories will be there in first. In Schedule 2, the provisions relating to President of India and governors. In 30, in Part 3, provisions relating to President of India, governors, the speakers. There are so many things are ABCDs. In A, presidents and governor. In C, speakers, provisions relating to speakers and deputy chairman, like this. Now the provisions relating to High Court judges, so Supreme Court judges, like that. These aspects will be there in Schedule 2. In Schedule 3, how the President of India has to take oath, how the governor has to take oath, how speaker has to take oath, judges have to take oath, like that. Those particulars are there in Part 3. Part 4, the administration of some scheduled tribal areas, scheduled areas. In that particular area, tribal people will there. How the administration is to be taken up specially, that type is to be there. Then and Schedule 5. So like this, there are different one schedule is there. Schedule 6 is there for the special provisions for Assam, Meghalaya, Mizoram, Tripura, Mizoram. Some special provisions will be there for those tribal areas. Now Schedule 7 tells you lists. What are the subjects of central government, what are the subjects of state government, what are the subjects of common. Suppose some subjects, Army, Navy, Air Force are central subjects, central government alone can pass law. Some state subjects are there, excise, police. Police is both central and state subject. Center can pass law on police, state can pass law on police. So education, concurrent list, center can pass law, like that. There are like this. What are the languages allowed, will tell you one thing. So earlier there were only 8 schedules. After a constitution came into force, First Amendment Act was passed in 1951. Under that Amendment Act, Schedule 9 was passed. What is the importance of that Schedule 9? Here, as the time passed, population increasing day by day, requirements are more. Traffic is increasing, roads are to be widened. When roads are to be widened, the buildings beside the roads are to be demolished to widen the road. So railway roads are to be expanded. New roads are to be constructed. In order to construct new roads, some lands are to be acquired. Similarly, if the government wants to construct some drainage, some buildings are to be removed. So those buildings owners, when they are demolished, earlier, by the time of Indian Constitution, right to property was a fundamental right. When the right to property, right to acquire property, right to dispose of property, right to transfer the property was a fundamental right. If anybody by executive action or legislative action, government by executive action, GO or GR, or parliament by passing law takes away that particular property of that man, he could go to High Court or Supreme Court under Article 226 and 32 respectively to get his property back. Now, if this is the situation, the government will not be able to take up so many welfare projects. For that purpose, the right to property, which was a fundamental right under Article 31 and 19(1)(f) was removed, deleted, abolished, and it is reformed into Article 300A, is the outside directive principles and fundamental right, and kept under Article 300A. Now, right to property is only legal right or constitutional right. If anybody takes away, if the government takes our property for welfare development or public projects, we are helpless. The government, whatever government compensation will give as per rules, we have to accept. If we go to court, we will not get any remedy. So if the property acquired is a minority's property, some Christian minority community, mean in a particular area with the population of whom is very less. In India, in some countries Hindus are more, some countries Christians are more, some countries Muslims are more. So which community has majority population and which community has a small population, that community which is having small population is called minority community. It may be Christian community, it may be Muslim community in India. So in Muslim countries, the Indians or Hindus will be become a minority communities like that. So dear friends, since this is what is called when the constitution was there, time to time amendments are to be made. So whatever to government, the parliament under article 368 is given power. The parliament has the power to amend various provisions of the constitution. Amend means to bring about change. What is the present rule? That present rule is removed and a new rule may be made, or this present rule provision may be modified, or present provisions may be removed and new provisions may be incorporated. Like that, articles 320A, 323B, 21A, like that, so many new articles will come. When once these additional articles are added to the constitution through various amendment acts, so when law is to be passed, when law is to be made, the procedure is same. Any amendment act is to be made, the procedure is same. In Indian constitution is also amended, and so many criminal laws are amended. All acts, all enactments will be amended from time to time, because the socio-economic conditions at the time of passing the act and the socio-economic conditions at the present today are entirely different. That is why in consonance with the changing conditions, economic, social, political, cultural and otherwise, the conditions are to be changed and the laws are to be changed. Sometimes the laws will be as a whole will be recodified and decodified and will passed into new laws, like that Consumer Protection Act to Consumer Protection Act, Motor Vehicles Act are recodified. Companies Act 1956 has been recodified in 2013 and like that. But one day or other, the Constitution of India also may be recodified, or any laws which are long back passed may be recodified in future. So this is the reason. So that is why when Constitution was passed, it contained 395 sections, 22 parts, 22 parts and 8 schedules. Thereafter, today we have 448 articles, 22 to 25 parts. 3 parts are added extra, and similarly, and at that time 8 schedules are there. Now 12 schedules, 9th schedule is added. It contained article, it refers to article 31B, because new schedule is added. So the new schedule contains some laws. If any state government passes any agrarian law to acquire private property private property, the owner of that individual property cannot question. In the beginning, 8 legislative agrarian laws were passed by different states, subsequently 30, and today they are 245 or 85 agrarian laws are there under article under schedule 9. So this is the significance of article. Now coming to the this area historical background, features and all I will take up in next class. Now coming to the, I am telling you the syllabus and the contents. So the background of constitution I told you. Now coming to the next, in constitution you see any textbook, the first chapter will be introduction. In introduction you study what is constitution, what is constitutional law, what are the kinds of constitution, what are the kinds of constitution, what are the features, one chapter. What are the features of constitution is one chapter, and the historical background is one chapter. Federal features is there, and ultimately preamble is there. These are shown in one or two topics, may be shown in one chapter or different chapters. So these are the preliminary concepts. When once you study about this historical background, meaning, definition and kinds of constitution, features of Indian constitution, features of Indian constitution, next features of Indian constitution, federal features, preamble, you will have very good idea and background of the constitution. These aspects I will take up in detail in the next class, part 2 of the summary. And part 3 of the summary, I will explain fundamental rights, directive principles and fundamental duties. I will enlighten you in part 3. So this is this thing. Now coming to the, after the preliminary concepts, part 1, now part 1 we have to discuss. This part 1 to part 1 contains 4 articles. Part 1 of the Indian Constitution contains 4 articles. In Article 1, title of the name and name of the union and its territory. Article 1 speaks about union and its territory. What is the title of India? India, the Bharat. It contains what are the states, what is the name of the union, how many territories are contained. So it Article 1 with 3 subsections ABC speaks about the territory of India, that is the Union of India and Union of India and all these things. And now article what is the so this article, what is India, how many states and territories are contained in this. It is established, it is provided under schedule 1 of the Indian Constitution. So that is what Article 1 tells you. Article 2 speaks about admission and establishment of new state. So when the state of India wants to take a particular territory into its state or union territory, or when India wants to discard a particular thing, acquisition and establishment of territory. Article 2. So the Parliament by passing law is empowered to acquire particular new territory and establish state in that particular area. This is Article 2 of the Indian Constitution. Under Article 2 of the Indian Constitution, Parliament can pass a law and it can acquire new territory and it can give some name and establish a state and provide appropriate infrastructure for governmental machinery. That is Article 2. Article 3 speaks about bringing about some changes in the states. To split one state into 2 or 3, or to take one part of one state and take another part in another state and join it, to make one state into 2. This power is vested with Parliament under Article 3. The Parliament under by passing a law by passing a law can increase the area of a state, decrease the area of a state, discard particular area from one state, discard particular area from another state, and can establish new state. That is how Uttaranchal, Jharkhand, Telangana, and so many states are newly created under the power of Article 3. So to exercise this power of Article 2 and Article 3, Article 4 gives, Article 4 of the Indian Constitution confers power on the Parliament to exercise such power to acquire any state, establish any state, increase the state, decrease the state, split the state, and discard one area from one state and another area from another state, club it or merge it and constitute new state. All these powers are vested with. So Part 1 of the Indian Constitution speaks about union and its territory. It consists of 4 articles. These 4 articles we have completed. Now second thing is, next Part 2. Part 2 speaks about citizenship. Part 2 of the Indian Constitution speaks about the citizenship. So Part 2 we have 20. Today we have 25 parts, but by name we have 22 parts only. So ABCDs are not a part, different parts are there, Part 4A like that. Some new parts will be there for reserved areas and all. So technically, what is the serial number was given at the time of Indian Constitution, the same serial numbers from 1 to first number to last number are given. Now second, Part 2 of Indian Constitution contains Article 5 to 11. Article 5 to 11. Part 2 of Indian Constitution contains 5 articles. So according to Article 5 to 7, this speaks about citizenship. So whoever is born in India is the citizen of India. What do you mean by citizen? What are the rules for citizenship? How to acquire citizenship, how citizenship is granted, how if by Indian migrated to other place, other people migrated to India, what is the process, what is the migrants from India to Pakistan, Pakistan to India. All these rules of citizenship are provided under Part 2 containing Article 5 to 11. However, Article 11 of the Indian Constitution gives power to Parliament to pass a law to frame the rules of citizenship by virtue of the powers of in pursuance of the powers conferred under Article 11 of the Indian Constitution. The Parliament passed an enactment called the Indian Citizenship Act. This Indian Citizenship Act, Indian Citizenship Act 1955. So today, under Article 11 of Indian Constitution, the Citizenship Act 1955 passed. As per the rules of a Citizenship Act, the acquisition of citizenship, loss of citizenship, and all the rules will be acquired. So now, second part is Article 5 to 11 deals with citizenship. Third, Part 3 is a fundamental right. Fundamental Part 3 of the Indian Constitution contains Article 12 to 35. All these articles deal with fundamental rights. Part 4 of the Indian Constitution contains Article 36 to 51. All these articles deal with directive principles. So, what is fundamental right? Under Part 3, Part 3 of Indian Constitution contains Article 12 to 35. All these articles 12 to 35 deal with fundamental rights. Article 4 to Article 36, Part 4 article contains article 36 to 51. All these articles deal with directive principles of state policy. So, what is the background of this fundamental rights and directive principle? For survival of human being, some rights are very, very important. They are inherent. They are inherent needs. They are inherent needs. To inhale air is inherent. To inspiration, expression are inherent. To take food is inherent. To discharge waste from the bodies are inherent. So they are called inherent needs. The man can to sleep is inherent, like that. So these are, without them the man cannot live, man cannot survive. Like that, human being needs some rights. Without those rights, there is no survival of human being. A man, to survive and live peacefully and pleasantly, he must have some rights. Those rights are called human rights. There are 30 human rights identified, acknowledged by World Union, the United Nations Organization, in Universal Declaration of Human Rights. These 30 rights. So they are right to life, right to liberty, right to life, right to personal liberty, right to livelihood, right to education, right to work, like that. So many rights are there. Those rights are called human rights. Human means human being, man or woman or misgender, cannot live without exercising these rights. That is, those rights are called human rights. The the members of conscient assembly, the drafting committee, the members of drafting committee headed by Dr. B.R. Ambedkar, the chairman of the drafting company, took a lot of strain, made untiring efforts to demarcate human rights, demarcate these human rights as fundamental rights and directive principles. The human rights of great importance, great significance, without which a man cannot live, have been embodied, enlisted under fundamental rights, and the rights of human rights, which are comparatively less important, are enlisted in directive principles of state policy. Means the Constitution protects a fundamental right. Anybody who loses fundamental right by executive action or legislative action, he can go to High Court or Supreme Court under Article 226 or Article 32 of Indian Constitution and get back his fundamental right. So the Constitution gives guarantee. The courts protect fundamental rights. So there are some other human rights are given as directions. You give these rights, protect these rights. So the Constitution gives directions to union government and state governments to implement these, to protect the welfare, to protect the well-being of the people. Those fundamental, those inherent human rights, those human rights are listed as directive principles. So fundamental rights are the rights protected and safeguarded by the Constitution through courts of law, through High Courts and Supreme Court. But directive principles are guidelines for welfare of the people, free education, ladies facilities, protection of various amenities for ladies, various amenities, right to education, right to legal aid, right to pollution-free environment, like that. What are the needs and necessities necessary for a human being are listed under Part 4 of the Indian Constitution under Article 36 to 51. So, Part 3 of Indian Constitution containing Article 12 to 35, these articles speak about fundamental rights. Part 4 containing Article 36 to 51 deal with directive principles or state policy. These all directives are human rights, but they are comparatively less important when compared to for fundamental rights. So the government, the constitution gave direction to the states to implement those welfare measures, security measures for the well-being of the people within 10 years of the constitution, subject to financial viability, financial stability of the concerned state. So if fundamental right is not followed, strictly adhered to, the court will take cognizance to protect it. If directive principles are not strictly adhered to, the courts cannot take cognizance of the interest of the individual. So now let us now speak about fundamental rights. Fundamental rights are such a human rights without which a man cannot live. Fundamental rights are such great important human rights without which a man cannot live or survive. Here, among the fundamental rights from Article 12 to 35, Article 12 to 35 contain so many fundamental rights. So, Article 12 speaks about state. Article 12 speaks about state. If fundamental right is affected, violated, infringed, whom the court, the aggrieved party will approach the court against whom? Against whom? A man's fundamental right is taken away. He should go to court. Against whom to get the remedy? It is the state. The state is answerable, accountable. What is the state? Earlier, state government, central government, parliament, central legislature, state legislature came within the meaning of state. Subsequently, judiciary came within the meaning of state. Local bodies came within the meaning of state. All authorities, corporations, etc. Everything, whatever authority or body passes by act or enactment or legislation, GO or order, infringes, takes away the fundamental right of the citizen. The fundamental rights are citizen, they are available to citizens only. Then that individual, that citizen can approach the court by filing writ petition under Article 226 in High Court, or under approaching Supreme Court under Article 32. He can get the right protected against state or parliament or state assembly or any political authority, any corporate authority or local body or municipality, panchayat, whatsoever may be. If fundamental right is affected, he can approach. All the authorities come within the meaning of the state is what you are going to discuss in detail under Article 12. Article 13 tells you what is law. What is law? Article 13 tells you what is law. Details I will explain. Article law, basically in Article 13 we should discuss about Article 13 Clause 1 and Article 13 Clause 2. What is law? What our Indian Constitution says is law. Constitution says is the law. Means whatever is there in Constitution, any law must be according to the Constitution. Our Indian Constitution came into force on 26th January 1950, but this before 1950, so many laws, legislations were passed during British period. In Third Law Commission, 19 legislations were passed from Third Law Commission 1861 to 1860, and subsequently till 1950, many more legislations were passed by the British Parliament. Innumerable number of legislations were passed. So whatsoever legislation that was passed by the British Parliament prior to in constitution came into force, those laws, the rules, regulations, provisions, clause, subclauses or anything must be according to the provisions of Indian constitution. Any particular provision, chapter, section, clause, subclause should not be against, should not be inconsistent, should not be contrary to any provision of the Indian constitution. If so, that particular enactment as a whole or in part was to be declared void, invalid, illegal, unconstitutional. So the laws before Indian constitution were called pre-constitutional laws. According to Article 13, Clause 1, all pre-constitutional laws must be consistent with the provisions of the Indian Constitution. Otherwise, that means if they are inconsistent with Indian provisions of Indian Constitution, they were void, illegal, unconstitutional. So, laws were there before Indian Constitution 1950, laws were passed after Indian Constitution came into force by Indian Parliament. So, whatever law was passed by the Indian Parliament after Indian Constitution came into force, the Google tells there are more than 1901, 1001 survey, 1300 plus 130, the central legislations are passed. Now 375 legislation bills are pending in the parliament, and the constitution amendment 130 bill is there pending, but up to constitution 106 the Nari Sikh bill was passed and in the process, and constitution 106 amendment act is passed, 107 amendment act has not yet been passed. If all 130 are to be implemented, constitution 130 amendment act will be there. So dear friends, here so even constitution came into force, whatever laws that are passed after 26 January 1950, those laws must be according to the provisions of the Indian Constitution. If state pass any law, it must be according to Parliament. That law must be according to this thing. When the Parliament gave power to the subordinate bodies, executive, states and local bodies, whether the state legislature through the governor passes any legislation, the provision must be according to Constitution. And if local body passes any law, that municipal authority or any authority, local authority, it must be according to state legislature and according to parliament and according to constitution ultimately. So just like that, it is the thread should pass through all the holes in a same direction, just like so. This is what is called pre-constitutional law, post-constitutional law. However, in pre-constitutional laws, if any corrections are to be made, those corrections are to be done by some special doctrines like doctrine of eclipse, doctrine of severable legislation and all these things. Those aspects I will take up in the respective topic of this fundamental rights, third part 3. Now coming to after 12 and 13, we come to 14. Article 4, after Maneka Gandhi versus Union of India 1978 Supreme Court, there are among all fundamental rights from Article 12 to 35, the most important rights are fundamental rights are Article 14, 19 and 21. These three vital articles 14, 19 and 21 have been described as the golden triangle of the Indian Constitution, golden triangle of the fundamental rights. Among all articles right from 12 to 35, Article 14, 19 and 21 are the most important fundamental rights. They are called, described as golden triangle. Article 14, which is borrowed from Dicey's Rule of Law, England, and Article 14, equal protection of law, borrowed from American Constitution, is divine law, the rule of law. According to Article 14 of the Indian Constitution, all citizens in India must be treated alike irrespective of sex, race, religion, caste, everything. All in the eyes of law, all are equal. In the eyes of law must protect all, right from Prime Minister to police constable. Law must give same protection. So this is what is called rule of law. According to Article 14 of Indian Constitution, all citizens, the Constitution of India guarantees each and every citizen and non-citizens equality before law and equal protection of equality before law and equal protection of laws. So suppose if any justice is done, if anybody approaches police station or court, equal justice should be given. So for rich man, more justice, poor man, less justice is not there. Whoever goes to court, whoever commits wrong, he is punished. So even Prime Minister should be punished. So in Pakistan, President Bhutto was hanged. So similarly, so death sentence was awarded to some state country leaders also we had. So even Mrs. Indira Gandhi, one of the very few great, dynamic, highly talented, most able administrator, Mrs. Indira Gandhi had to face litigation and stood before the Allahabad High Court. She was given judgment against her by the then Chief Justice Sinha of Allahabad High Court, who declared her election invalid and asked her to resign the job. She was debarred from contesting following elections and all. For subsequent so many developments were made. I explained in so many times, and I will explain in future when we come across that situation. So even king is not above the law. The king must be above the law. The rule of law may be termed as divine law. It is act of God. So according to this, so here the Constitution through Article 14 envisages, guarantees equality before law and equal protection of law. So this concept, equality, must be treated among equals. So equality treatment among unequals would not result in equality, because if equal treatment is given before among the unequals, it would result in this thing. For example, dear friends, in a classroom, there is merit students are there, poor students are there. If the teacher gives same teaching, same standard of teaching, the rich student, the intelligent student will follow easily, whereas the poor student will not be able to understand so easily. In such time, the poor student should be given extra time, and he is given some extra private class and will be taught separately. For that, the intelligent student should not think that the teacher is discriminating me. No, because in order to uplift the downtrodden poor student as good student, some additional coaching is given. Similarly, there are so many people who are downtrodden, socially and economically backward. So these socially and economically backward people as citizens are given some special privileges, some fringe benefits, reservations and all. Reservations in educational institutions, reservations in jobs, they are provided by Constitution by providing special privileges to these downtrodden people under Article 15 Clause 4, protective discrimination for seats in educational institutions, and 16 for employment opportunities to to these creamy layer, to downtrodden. So that is why the Supreme Court made it very clear that equality before law and equal protection of law to among equals sometimes result in inequality. So in order to balance equality among all, unequal treatment in certain instances with reference to upliftment of the downtrodden is incompatible and inevitable is what Supreme Court said. Thereby some special provisions through reservation have been provided to the socially and economically poor candidates. So this is what Article 14 tells you. So Article 19 of the Indian Constitution, 14, one golden triangle, first wing is Article 14, second wing is Article 19. Article 19 of Indian Constitution, at the time of passing, it consisted of 7 freedoms. Suppose you are at home, your parents are giving you lot of education and everything. Your parents don't allow you go outside and they arrange in some movies. Teachers, everything is arranged within 4 walls. You have not seen what is going outside. There is no any use. Some one Telugu movie is Prema Mandiram. It is there. Akini Nageswara hero was confined to 4 walls, not allowed every outside. He did not know anything. So that is why one must have freedoms. Without freedom, there is no use of any, there is no survival of life. So Article 19 provided 7 freedoms. 19(1)(a), freedom of speech and expression. It includes press also. So if freedom is exercised unlawfully, restriction is there under Article 19(2). Second freedom is freedom of association, freedom of assembly. Freedom of assembly means some people can sit together, gather together for anything. That gathering together is to conduct some personal meeting, to attend some function, to celebrate some temple ceremony or any function, sitting together, or employees to sit together to discuss about their salary and other benefit. If a group of persons sit together in a peaceful way without using any violence, without resorting to any violence, without resorting to any with any deadly weapon, without causing any mischief, that assembly is peaceful assembly. So they are entitled to fundamental right guaranteed under Article 19(1)(b). In case they turns the assembly into unlawful assembly by resorting to violence, by resorting to create public unrest, to threaten the public peace and security. They stop vehicles. They are not allowing a government servant to do his duty, what he ought to do. But they insist a government servant to do a duty, what he ought not to do, So that assembly comes under, will become unlawful assembly. So this freedom under Article 19(1)(b) cannot be available under Article 19(3). Article 19(3) imposes certain reasonable restrictions. The third freedom is freedom of association. Freedom of association is also very important. In an industrial establishment, thousands of workers are there. If any worker is removed from service, he alone can fight with the government. Can fight with the union. Suppose that industrial establishment, factory, has some union, trade union. If he is a member, the union as a whole, all workers as a whole, question the management for removing the employee, removing the worker unlawfully, then the management will come down and reinstate him. So For that purpose, freedom of association, workers associations are there, staff associations are there, officers associations are there, bank associations are there, LIC associations are there, all employees associations are there, all workers associations are there. If anything injustice is done to any member of the association, he can approach the authorities through the association or union, so that he will be able to get justice. For that purpose, the freedom of association is provided for under Article 19C. 19(1)(a), freedom of speech and expression, including freedom of press, even press also. It also includes freedom of silence. So standing simply without singing national song was treated as a violation of fundamental right. The student was expelled in Biju Ammal versus State of Kerala, as Kerala High Court confirmed it, but Supreme Court said that he stood and respected the national anthem, though he did not speak. The freedom of speech and expression also includes freedom of silence, is what the Supreme Court said. So freedom of speech, 19(1)(a), reasonable restrictions, 19(2). If anybody speaks nonsense about anybody, he will subject to defamation case and other things, assault, battery, or other things. So now coming to the 1C, 19(1)(d). 19(1)(d) speaks about freedom of movement. This freedom of movement means freedom to move anywhere in India. So the freedom of movement guaranteed under Article 19(1)(d) is applicable to citizens, and it applies to within the country. Your reasonable restrictions are there under freedom of movement 19(4). 19(1)(a) restrictions 19(2), 19(1)(b) restrictions 19(3), 19 association 19(3), movement and residence 19, freedom of movement 19(4) is there. That is movement. Just like personal liberty, this Article 19(1)(d), these are identical. 19(1)(d). Freedom of movement. So this Kausalya versus State of Andhra Pradesh, one prostitute resides in some residential area. She claims freedom of movement, but the court said, so the freedom of movement is for genuine causes. If prostitute lives in residential areas, it would cause a lot of inconvenience to the neighbor housewives. So she should not reside in such residential area, and her freedom of movement was not protected. Similarly, next 19(d) is over. E. 19(1)(e) speaks about freedom to reside and settle. Any Indian, anybody can settle anywhere in India, any state or any country, any state or any village or whatsoever. He can reside anywhere, he can settle anywhere, nobody can question. If one person, Andhra Pradesh man, goes to Maharashtra or Gujarat for employment purpose, after employment he resides, settles there, that people cannot say, you came from Andhra, why you are settling here, you go back, is what no one can say. If it is done, then he can invoke relief through a court of law for his fundamental right guaranteed under Article 19(1)(e). So for this also the reasonable restriction is 5. Next one is EF. F means fundamental right to acquire, possess and dispose of the property. So this Article 19(1)(f) and Article 31 of the Indian Constitution was a fundamental right. In Constitution 42nd Amendment, this fundamental right was discarded, and Article and a right to property is no more a law at present. Right to property is no more a law at present Article 19(1)(f) and Article 31. These two fundamental rights were abolished by constitutional amendment, and right to property is now legal right or constitutional right. So because I told all these things about the right to property. Next one is sixth right is freedom of profession, occupation, trade, etc. So anybody, he can choose any profession of because a man to live, he should take up some work for livelihood. No one can get food free of cost. He has to do any work. He can take up the parents. He can. He can take up the profession of family profession or any profession which must be illegal, which must be legal. It must not be illegal or prohibited. So everybody is at liberty to take up any trade or business. Article 19(1)(g). So is a fundamental right. So if that business is illegal, if the reasonable restrictions are there under Article 19(6). These are the 6 freedoms, dear friends. So the earlier there were 7 freedoms. One freedom was discarded. One freedom was discarded. So there are 6. These are Article 19 is second wing of golden triangle. Third article is Article 21. Among all fundamental rights, the most important article is Article 21. I don't think whether there is any question paper without question on Article 21. Article 21, originally by the time Constitution was drafted, it contains guarantee for 2 things. One is life, other is liberty. One is life, other is liberty. So you have right to live. Nobody should ask you to kill yourself, or nobody should kill you unnecessarily. So liberty wherever you want to go, anywhere in India, wherever you want to go outside India, subject to a passport and visa, nobody should prevent you, provided that your freedom, you exercise your freedom for a normal purpose, genuine purpose. If you go exercise your freedom to other country to put bomb there, your freedom cannot be there. If you go to other country to do some illegal activity, your freedom cannot be there. So that is why Article 21 of the Indian Constitution guarantees right to freedom of speech and right to life and personal liberty. In the beginning, by the time Constitution came into force, this through Article 21, Constitution gave guarantee for 2 things: life, liberty. The guarantee, if life is affected, liberty is affected, Constitution protected through High Court and Supreme Court. Against, if the life or liberty is affected by executive action, that is the action by government through GO or GR, life is affected, liberty is affected, that the individual would be able to go to court, whether citizen or non-citizen of India, to protect it. No. After Karak Singh and Maneka Gandhi, Karak Singh, the right to protection is extended. Right to life and liberty, protection under life and liberty is extended to legislative action, law passed by parliament or law passed by state legislature. So earlier, if life or liberty are affected by executive action only, he could go to court. If life or liberty are accepted by legislative action, law passed by parliament or law passed by state legislature, he would not able to approach the court. Now, after Karak Singh's case, this liberty is expanded not only from executive action but also from legislative action by law. He could approach the court and get his life and liberty protected. So, in course of Maneka Gandhi versus State of Union of India, Maneka Gandhi was the wife of Sanjay Gandhi and daughter-in-law of Mrs. Indira Gandhi. She was in opposite party from the beginning, and when Mrs. Gandhi was in power, she was in opposite party. When Mrs. Gandhi Congress was not in power, she was in opposite party, was holding the post of minister. So Mrs. Gandhi at that time applied for passport, but her passport was impounded on security ground. In that, so many discussions, debates took place, and then after the Maneka Gandhi's versus Union of India 1978 Supreme Court, the scope of Article 21 is being expanded from time to time. Earlier, life, liberty, subsequently, so many things. Right to work is added, came under right to work, right to privacy, right to livelihood, right to shelter, right to legal aid, right to education, right to die, so many aspects, right to burial, right to medical aid, right to free environment, free pollution free environment, right to free burial, right to cremation. All these things are expanded from time to time. In general lectures, I explained in detail Article 21. All the lectures under Constitutional Law 1 were uploaded in English long back. Long back, dear friend, you can check them. You can check them. So the scope of Article 21 is expanded from time to time and is being expanded till today. So the scope of article earlier confined to, at the very beginning, confined to security against executive action. Then legislative action also, one could protect life and liberty. Earlier, one could approach court for protection of life and liberty only. Subsequently, for right to work, right to duty, right to wages, right to everything, so many things including environment, legal aid, die. So the right to die, actually I told you, dear friends, what was the most important fundamental rights are most important human rights which are inherent, without which a man cannot live, are listed in fundamental rights. And the secondary rights are listed in human rights are listed in directive principle. Directive principles mean the directions given by the union constitution to the state governments, union government and state government, to implement so many welfare measures to the people to ensure their security and to establish welfare state. They were called directive principle. But what was a luxury yesterday has become necessity today. For example, take the case of a common man. He gets salary of 20,000-30,000 salary. So he has to give house rent, children's school fee, provisions, milk. These house rent like this, they are main important. So if wife's necklace demands necklace, daughter demands scooty, son demands motorbike, they are secondary. So as time passed, wife's necklace is made necessity, son's bike is made necessity, daughter's scooty is made necessity. So in those days, in the olden days, India comprised of illiterates. More than 80% people in India were illiterates once upon a time. Today, the literacy rate is increasing day by day. Most of them are literate. If you check the Google, you can have the latest information of literacy in India, country as a whole and state as a whole. In worldwide literacy also, you will be able to find out. So the literacy rate is more. So in those days, our grandparents at that time were illiterates. My mother was an illiterate. So many our future generations people were illiterate. So education was not treated as that much. So when by the time the constitution came into force, the right to education was put in directive principle. The constitution directed the states to give free and compulsory education to the children up to the age of 14 years under Article 45 of the Indian Constitution. But that right to education came for discussion in Undikrishnan Mohini Jain versus state of Karnataka. In that case, private medical colleges were started. There were fees were collected. The state government passed regulation of capitation fee under that. different free structures were there. Some class of people 2,000, some class of people 15,000, some classes of students 60,000. So Mohini Jain was a girl who was from Uttar Pradesh, sought admission in that Karnataka medical college. She was asked to pay 60,000. She approached the court and claimed that right to education also must be treated as a right to life and liberty guaranteed under Article 21. But the High Court it was treated as right to life under Article 21. Education also was added in Article 21. Subsequently, Unikrishnan versus State of Andhra Pradesh, all the managements of engineering medical colleges approached the Supreme Court. If Mohini Jain case is followed, we won't be able to establish medical colleges, engineering colleges with a lot of infrastructure facilities, investing crores of rupees. Unless we get sufficient free, collect from sufficient free, we won't be able to run the colleges, medical engineering. We have to shut down the colleges like that. Then in Unikrishnan, they said the right to education is should be treated fundamental, can be made possible up to 14 years in preliminary education. In higher education it cannot be possible, and is liberalized. Mohini Jain case is liberalized, and the management were allowed to collect some capitation fee for survival of the institutions with moderate profits. So that is the case. That is what Article 21. So this right to education was added in Mohini Jain Unikrishnan case as one of the points in Article 21. In subsequently Article 19 was this right to education is made independent fundamental right. Is made independent fundamental right. This is made independent fundamental right, and Article 21A. So, according to Article 45, Constitution gave direction up to 14 years free and compulsory education. The government should provide within 10 years after the Constitution, and that is within 9. So subsequently, according to this, from 6 years to original, according to Article 45, up to 14 years. From now today, after 86th amendment, the Constitution 86th amendment took place in 2002, but it implemented in 2010. So many years gap it took place in from 1st April 2010. Dear friends, I told you the Constitution amendment may be passed, the Act may pass today, came into whether it may came into force immediately after 1 year, 10 years, 6 years, we cannot say. These aspects I have explained in so many lectures. You please follow them. So actually the right to education originally under Article 45 directive principle. According to that, Constitution gave direction to the states to implement free and compulsory education up to 14 years. But this education concept is made fundamental rights as one of the points in Article 21. Subsequently, the Constitution 86th Amendment Act was passed in 2002. That the Amendment Act which was passed in 2002 envisaging Article right to education as a independent fundamental right, it came into force from 1st April 2010. So after passing of Amendment Act, after 8 years, this Amendment Act came into force. Now Article 21A is independent fundamental rights, separate and independent fundamental right. So this is what is called Article 21. Now we have completed golden triangle 14, 19, 21. 14, 19, 21. After 14, what is 15? 15 means Article Through Article 15, the Constitution guarantees, Article 15 guarantees equality before law, no discrimination on the ground of sex, race, religion, etc. So through Article 15, the Constitution tells all are treated males, females, misgenders, any religion, any caste, any communities, all are provided equal facilities. There will not be any discrimination said. Article 1 and 2, some provisions are given. Secondly, Article 15.3, some special provisions are given to women and some specialized class. 15.4, some reservations are given to downtrodden people in educational institutions. Similarly, Article 16 also, while giving employment, there should not be any discrimination on the ground of sex, race, religion, etc. That is Article 16. All are given equal opportunities in employment. So, some the women are given some special treatment in according to Article 16.3. 16.4, some reservations are given to downtrodden. Subsequently, so many commissions are started, so many provisions are made. So that is about 16. Article 17 speaks about untouchability. In olden days, there are some downtrodden people, so lower caste people were ill-treated by upgraded upper class people, and if that lower class servant was not allowed to move with this, the social justice was not there. Their houses were they were asked to construct their houses outside the town or village. So that particular area was called scheduled caste, that area only. So those people are not, there is no any social interaction between those downtrodden people. They were treated as untouchable. So Mahatma Gandhi said untouchability is a serious crime. It must be eradicated. The menace of untouchability must be eradicated. And Article 17, Dr. Ambedkar ji made untiring effort to abolish this, and Article 17 is prohibiting the untouchability. Basing on this Article 20, so Untouchability Offences Act was there is to protect and thereafter basing on this article, the Article 17 of Indian Constitution prohibits untouchability. If anybody commits untouchability, he is punished under according to Article 17. According to Article 17, the Untouchability Offences Act, Protection of Civil Rights Act was passed. Protection of Civil Rights Act 1955 was passed. So this act has some defects. Subsequently, some economic community, some special committees were constituted, and this Untouchability Offences Act 1955 was, so Article 17 of Indian Constitution prohibits untouchability. If anybody commits the act of untouchability, it is treated as offence. That person must be punished. So under Article 17 of Indian Constitution, the Article 35 in the Article 35 of Indian Constitution confers on Article 35 of Indian Constitution confers on Parliament power to pass a law. By virtue of power conferred under Article 35 of Indian Constitution, the Parliament of India passed an act called the Untouchability Offences Act 1955. So this purpose of this act is to eradicate untouchability. Subsequently, the untouchability, the purpose of the act was not did not serve purpose. Subsequently, some committees on Economic and Educational Development Committee of scheduled caste, so protection of scheduled caste was passed, and they brought about some recommendations and changes, and then some revised so many provisions under Untouchability Offences Act 1955 have been made. So the revised Untouchability Offences Act 1955 provides so many provisions prohibiting untouchability, treating it as an offence. If anybody commits that offence, they will be punished. This is what is called Article 17. Article 18 Article 18 tells you abolition of titles. You should not put any title on your own without given by the government. So in 1954, the government of India introduced some titles, namely Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Bhushan, Padma Shri. These awards are awarded to the people of great country, the people who made a remarkable contribution of public service, art, literature in various fields. Those they have to apply, and the judges, the team of judges will decide, confer these awards, and these awards are provided under on Republic Day through the President of India. Without that, nobody should put any title before his name without such order. So anybody, if any foreign country declares any title to President of India, Chief Minister of in India, or any dignitary in India, but he should not accept directly. He should accept with the consent and permission of the President of India. That Narendra Modi ji received some titles from other countries. So for that, the President of India has to sanction it and it should be consented by the President of India. Andhra Pradesh Chief Minister Chandrababu Naidu also was conferred some title. It was to be conferred consented by the President of India. This is what is called Article 18 tells you abolition of titles. 18 is over. 19 I already told. Number 20, Article 20. Article 20 of the Indian Constitution tells you Article 20 of the Indian Constitution tells you three concepts are more important. One is ex post facto law. Second one is Article 21A tells you ex post facto law. Article 21(2) tells you double jeopardy. Article 20 Clause 3 tells you self-incrimination statement. All these topics are explained in detail in English long back, dear friend. Article 19(1) tells you ex post facto law. Any law is valid which is in force today. So Indian Bharatiya Shaksha Adhiniyam is valid today. Indian Evidence Act is no more valid today. So Indian Evidence Act provisions are not applicable. Indian Penal Code is no more today. So we should not apply Indian Penal Code rule. We should apply rule as per Indian Bharatiya Nyaya Sanhita. So whatever law is there today alone should be applied. Old law which was abolished should not be applied, or today a law is passed but it has not come into force by judge's notification. It may come after 1 month or 10 months or 1 year or 10 years. Right to Education 21A passed in 2002, but it came into force in 2010. So whatever law we impose past dated laws, post dated laws should not be applied. If they are applied, it is unconstitutional. In Nandakumar case is of great importance. In Raja Nandakumar case, old law, outdated law was applied and he was hanged out of grudge and vengeance, and hence Nandakumar was case hanging was declared as judicial murder. So anything, even today, whatever law is there in force, it must be applied. We must not, old law, outdated law cannot. In the Consumer Protection Act 1986, we cannot apply today. Consumer Protection Act, present act should be applied. So Motor Vehicles Act 1988 should not be applied. The Motor Vehicles Act in 2022 must be applied. So that is what Article 20 Clause 1. Article 20 clause 2 means if anybody faced the punishment, he should not be tried again, should not be punishment. So one offense, one punishment. For one offense, two or more punishments are not allowed. If anybody having undergone imprisonment for committing an offense, he should not be brought again to the court to be tried again and we should be punished again. That is what is called double jeopardy. When once a man committed a crime, he underwent punishment for that. Again, case should not be filed and punished. That is what is called double jeopardy. Third one is self-incrimination. Self-incrimination. What do you mean by self-incrimination? And these are the rights against arrest and detention. These three. So the court, no man who accused of an offense should be asked to give evidence against himself. Even real culprit also, a man who committed the offense really also will try to say no in the court of law. He wants to protect himself. But the police officer, whatever is said to police officer is not allowed, because police officers so beat and put torture and make the man speak something, but it is not allowed. Similarly, so the judge should not tell the accused, you tell the truth, you agree that you committed this offense, I will reduce your punishment. If the magistrate or a session judge tells, if he gives statement, that statement is not allowed in evidence, he will not be punished accordingly. So, no man, no accused should be asked to, forced to, compelled to give evidence against himself. He should give evidence on his own only, voluntarily only. If he is forced to give evidence against himself, then he can challenge it, that his fundamental right guaranteed under Article 20, Clause 3 is infringed or violated. He can approach the court and get his right restored. This is what is called. However, if he gives any statement, similarly, whatever evidence is given to police officer is not admissible. Suppose the accused in police station tells that I committed the murder. If the police officer tells the same in court, not allowed. According to Article 27 of Indian Evidence Act, now 25 of Bharatiya Saksha Adhiniyam, if the accused before police station gives evidence suo moto and gives some clue about the commission of the offense, then that is evidence, that is allowed. According to 27 Indian Evidence Act and 25 Bharatiya Saksha Adhiniyam, yes, I committed murder of Savaya. If you take me, I hid him in my garden. I dug a ditch and hid him in my garden beside coconut tree. If you tell me, I will show you the body. Then he tells everything suo moto. If the police officer tells the same in court, such evidence is allowed, and that evidence is allowed, and that evidence is allowed, and he will be convicted. So whether it is constitutional or unconstitutional is a question, is what I explained in detail in law of evidence, that is Bharatiya Saksha Adhiniyam. Dear friends, so now coming to the Article 20 is over, Article 21 is over, Article 20, prisoners' rights. Prisoners' rights. In prison, there must be security must be provided. In prison, the prisoners must be treated carefully. Suppose a person is arrested, receives arrest warrant, a police officer goes to arrest a person, he should tell him the reason for his arrest. After arresting, he should tell him the opportunities to bail. After arrest, he should be presented before the magistrate within 24 hours. After arrest, he should be given an opportunity. There is an opportunity for bail. If you can apply for bail, he should be informed. That is bail. Investigation should be done in time. Enquiry should be done in time. All proceedings must be done in time. All proceedings must be done in time. If death sentence is there, it must be executed in time. So no irregularities must be when in prison. prison, there are so many prison safety precautions must be provided, handcuffs, solitary confinement, and all these things are to be done. This is all, this literature you will study in prison reform in the subject criminology and criminal administration. Criminology and criminal administration. And now 22, so many prison after arrest and detention, so many precautions are there, protectionary measures are, protections are provided. Those protections must be strictly adhered to. If the protections are not provided for, then the aggrieved can approach the court. He himself can go, somebody may communicate, a co-prisoner or some outsider to the court. The court will take cognizance of the act and protect that particular prisoner. Article 22 is over. Article 23, 24, article prohibition of traffic in human beings and forced labor. Article 23 speaks about traffic in human beings. So, in olden days, human beings were treated like chattel, animals, cows, buffaloes, goats, sheep, and sold in a market. Sold in a market. So, sold in a market. So, young girls were sold in a market, children, boys, girls were sold in a market for bonded labor. So, they were sold. How a goat or sheep is purchased, how a cow or buffalo is purchased, the human beings are there. This is what is called traffic in human beings. If anybody resorted to the traffic in human being, he can approach the court and is protected. The culprit will be punished severely under Article 13. So, next one is, fourth one is 24. Article 24 speaks about forced labor, child labor. Children below the age of 14 years should not be compelled to, should not be compelled. So, beggar means traffic in human beings, and human beings are sold. Beggar means insisting, pressing human being to do an act which he is not willing. A man is taken away, he is forced to, a woman is forced to do prostitution, a woman is forced to do bonded labor. That is what is called beggar, forcing the person to do an act which he doesn't like to do. Then similarly, Article 14 and 24 speaks about forced labor, child labor. The children below the age of 14 years should not be employed in factories and other industrial establishments engaging hazardous and dangerous nature of manufacturing process. So, if at all children are allowed, there may be exceptional cases that only they may be allowed, but Article 24 of the Indian Constitution mandates that children below the age of 24 years, 14 years should not be employed in this. Now, 34 is over. Article 25. Article 25 to 28 deal with various provisions relating to freedom of religion. Freedom of religion. In detail, I will tell you. Right to Article 29 and 30 speak about minorities. According to Article 29, there are some minority communities. Minority communities mean in a particular area, state or country, the population, the people of more population are majority community, people of less population are minority communities. Minority communities. So, if they stay in a particular state, Muslims are more, Hindus are less, Hindus are minority community, Hindus are more, Muslims are less, Muslims will become minority community, Christians are less, Christians will become minority communities. So, these minority communities are on the ground of caste or otherwise, they may have their own personal language. They may have, their language should not be outweighed, ill-treated. That language, their language, how they, in what language they speak, in what language they write, that is called linguistic minorities. Their language should be protected, their script should be protected under Article 19.1. Article 19 clause 2, Article 29 clause 2, if they seek admission, they should not be denied admission in any educational institution if that educational institution is aided by the government. So when once a school or college is supported by government, in that particular institution, admissions must be open to all communities irrespective of sex, race, religion and all. There should not be any discrimination. That is Article 29 clause 2. 20 Article 30 tells you the minorities, Christians or Muslims or anybody, they can establish the educational institutions of their own. They can establish the education, they can run the educational institutions. They can, suppose a Muslim college is there, law college is there, law entrance is not necessary, directly they can take admission. So a Christian law college is there, law entrance is not applicable, directly they can take admission. So like this. Article 30. So Article 30 clause 1, like to establish admission. So here Article 30 clause 2, if the property of these maritime institutions is acquired by the state, there should be, the government should give aid, compensation properly. They should not deduct, and they protect the interest of the minority institution while acquiring the property. The reasonable compensation should be paid. That is what Article 30 clause 2 tells. The Article 30 is over. Article 31, which dealt with Article 31, which dealt with Article 31, which dealt with right to property, was abolished, and now it is reappeared. Article 31 and Article 19(1)(f), which dealt with acquisition, possession and disposal of property, transfer of property, is no more a fundamental right. It is abolished, and now it is reappeared in Article 300A. Right to property under Article 300A is a constitutional right or legal right. And now Article 31. Article 31A, saving of laws. Article 31A, 31B, 31C, 31D. 31D added and removed. We forget about it. Article 31A, 31B were added to Indian Constitution by Constitution First Amendment. Article 31C was added by Constitution 25 Amendment Act 1971. So what is the purpose? So article, in order to overshadow the abolition, in order to get corrected the abolition of our right to property, the Article 31A, 31B, 31C are added to Indian Constitution. So if property is acquired, if he approaches, if by state government or central government rule or regulation, if any property is affected, saying that my fundamental right is affected, he can go to court. So that is why, according to Article 31A, if state or if the government passes any rule or regulation, if any property is taken away, it is not subject to judicial review. He cannot go to court. Not subject to judicial review means, if anybody is aggrieved, if any person loses his right, loses his property, injustice is done, he naturally will go to court. There are certain circumstances in which, even if injustice is done, if his property is lost, he faced any loss, he cannot go to court because here is for judicial review. In certain so this 31A, 31B, 31C are outside the purview of judicial review. According to Article 31A, if any rule or regulation is there made by state and anybody loses anything, he cannot go to court. According to 31C, that is protected by that act of the state rule or regulation is protected by Article 31A. So he cannot go to court. It is justified. Article 31B is with reference to Schedule 9 of the Indian Constitution. This Schedule 9 is added to Indian Constitution. Schedule 9 is added to Indian Constitution by Constitutional Amendment Act 1950, First Amendment Act 1951. So, according to that, the state governments may pass so many laws called agrarian laws to acquire the public property for private property for public welfare. Suppose roads are to be widened, the properties are demolished. So roads are to be widened, new roads are to be constructed. People's lands may be, fields may be taken like that for railroad and all. When once properties of individuals, private properties of private individuals are taken by government for public property, for public purpose, the state legislature has to pass some law. Such laws are called agrarian laws. So for that purpose, the Constitution First Amendment was made, and Schedule 9 is added. Originally, Constitution had 18 schedules, but the Schedule 9 is added. It contained originally 8 laws, next 30 laws. Now there are 285 agrarian laws are there. Now, similarly, the so Article 31C speaks about anti-national activities, anti-national activities. So this that 431D is removed. 31C, Article 31C gives protection to Part 4. Here, Part 3 of Indian Constitution speaks about fundamental rights. Part 4 of Indian Constitution speaks about directive principles. If the government, state government, passed a law to give importance to directive principles, in that process, fundamental right is affected. Now the question is whether fundamental right is prevailed or directive person is prevailed. So, in order to give preference to directive principle under Article 40, under Part 4, this Article 131C is added to Indian Constitution under 25 Amendment Act. For example, there is a butcher. He cuts the cows and he leaves. So, right to live is, right to work, right to live is a fundamental right guaranteed under Article 21. So, the government of state government or central government and any government passed a legislation, cow slaughter is an offence, is a good offence, it is not allowed. No one can do this cow slaughter. It passed a legislation. So, when the government passed legislation abolishing cow slaughter, the butchers lost their livelihood guaranteed under, according to Article 19(1)(g) Indian Constitution, they can take up any profession, but their fundamental right guaranteed under Article 91(g) is affected, they approach the court. For that purpose, the Article 31C will come into picture. Even whenever there are certain circumstances in which the state may pass a legislation in order to give priority or uplift Part 4, then if fundamental right is affected, infringed, abridged and outweighed, the aggrieved should not go to court. So, as protected by Article 31C of the Indian Constitution. 31, 32, 33 is over, friends. Now let us go to Article 32. Article 32 of Indian Constitution is of great importance. So, any individual through Article 32 can approach the High Court Anybody can approach Article 30 under Article 32. An individual can approach the Supreme Court. Citizen and non-citizen, any citizen of India, any aggrieved party can approach the Supreme Court under Article 32 for protection of fundamental right, for public interest litigation, or any other rights to be protected. So, Article 32 speaks about locus standi and public interest litigation. Locus standi means a person whose right is affected alone can approach the court is locus standi. Public interest litigation means a public spirited man, a man who is having affection and love over the society, can approach the court for the welfare of the public. For example, the government passed a legislation stating that the doctors employed in government service should not do private practice. Then the doctors alone will have a locus standi to approach the court. Similarly, the teachers, lecturers, college lecturers should not do tuition, engage tuitions, and law passed. Then they may have locus standi to approach the court. So, if private practice is banned, teachers have no locus standi. If private tuitions are banned, doctors have no locus standi. So, like that, locus standi means right to approach the court. A person whose right is affected alone can approach the court is what? Locus standi. This is the traditional rule of locus standi has been liberalized with the inception of public interest litigation. It was the public interest litigation locus standi. Number of lectures I have given, dear friends, in administrative law and constitutional law topic wise. You please go through. These topics are very important from not only from examination point of view but also from this. So, any public spirited person under section 43 of CRPC, now section is changed, we have to BNSS, and 226 Indian Constitution, High Court, 32 Indian Constitution, Supreme Court can approach public purpose. Suppose roads are not good, one can approach court. The river water is polluted, Ganga river, one can approach court. Mosquitoes nuisance is there, Ratlam case, municipality case, he can approach the court. If downtrodden people are not given any facilities or water supply, public spirited man can go to court. So, any public purpose, public interest, environmental pollution or vehicular pollution or mosquitoes nuisance or whatever may be, if the government is not taking proper care in maintenance of law and order, maintenance of traffic control and other, any public person, irrespective of locus standi, can approach the court by filing a petition in first class magistrate court or subdivisional magistrate court under 143 CRPC or Article 226 High Court or under Article 32 Supreme Court. MC Mehta, one leading lawyer in one of the advocates in Supreme Court, filed so many public interest litigation petitions under Article 32 of the Indian Constitution. I explained all these things in administrative law. Now, 32 is over. So, Article 33 of the Indian Constitution gives power to the Parliament to make any law. In fundamental rights. So, Article 12 to 35 are fundamental rights. If they are affected, one can approach the court. But the Parliament, by passing law, can change the nature of this fundamental right. Suppose during emergency, the person cannot go to Parliament by pass law. No one can approach the court to protect his fundamental right. That particular fundamental right number it can give. That power is conferred on Parliament under Article 32. And 30. So 34. Article 34 speaks about so many laws are applicable to Indian territory as a whole, but they are not the martial for the laws, Army, Navy, Air Force. They have their special legislations. They are bound by the particular laws, Army, Navy, Air Force, and some other people. And when you read any act, applicability of act, this law is applicable to the whole territory of India, including Jammu and Kashmir, like this, they said. But the law is not applicable to the area where martial law is in force, like this. So the people of Army, Navy, Air Force, they may have their own laws. They are bound by them. It is not there. According to Article 14, 34, certain restrictions may be there that certain laws may not be applicable. So Article 35 speaks about legislation to give effect to the provisions under Part 3. So, the Parliament under Article 35 can pass a law to give effect to the some fundamental rights to come into force. Now, the Part 4 of the Indian Constitution speaks about fundamental directive principles. The directive principles Part 4 are called DPSP, Directive Principles of State Policy, and Part 4. Article 36 to 51 of the Indian Constitution speak about various guidelines given to the state. The state of within 10 years of Constitution, that is before 1960, should implement some welfare measures for welfare of the people, free legal aid, free education, pollution-free environment, so many economic charter is there, social security charter, so many things are there to uplift the ideals and goals enshrined in fundamental duties. So these fundamental rights are the directive principles are directions given to the state governments to implement, but the directive principles are only directions. If the financial position is good, the state can implement. The directive principles are not enforceable. So if the government should not implement the directives given by the Constitution, no one can approach the court for implementation of this. So free legal aid and all, so many things are there. So some of these directions are added in fundamental rights also. After Maneka Gandhi case, Article 21 was Article 21 is expanded. So many items in directive principles are added in Article 21. So what was directive principle yesterday is a fundamental right today. Some directive principles are there. Article 36 to 51 under Part 4 lay down various directive principles. This thing. So last topic is Part 4A. Part 4A of the Indian Constitution was added to Indian Constitution under 42nd Amendment Act in 1976. This article Part 4A has only one article, that is 51A. This, according to 51A, it contains some fundamental duties. By the time the Constitution was passed, this is added, only 10 fundamental rights were there. But later, in Constitutional Amendment Act, Subsequent Amendment Act, 11th fundamental duty also is added. Now, A to J, 10 fundamental duties were there. Now K, another fundamental duty is added. These topics I will discuss in this thing. In fundamental duties mean right to salute the national flag, right to sing a national anthem. If the citizens, you have to protect the unity and the integrity of the nation. If government, you are asked to go to government servant, you should go. Suppose if any war is there, military is not sufficient. The public is required to go to war. We should go. So no, if you are asked to do election duty, you must do it. And integrity, you should treat all people like your brothers and sisters. What are the ideals or goals instead in preamble of a constitution? As a individual, as a human being, as a citizen of the India, you must uplift the unity, integrity, and of nation. You should tell all communities as brothers and sisters, and you have to. The principle of fraternity should be strictly adhered to. The four pillars of the constitution: justice, liberty, equality, and fraternity should be uplifted. This is all. These are various fundamental rights directed. That is why Arch Salman, a distinguished jurist, said that rights and duties are correlative. If you claim any right, you must have duty. When you are claiming fundamental right, at the same time you must claim you must have fundamental duty. So if you don't adhere to duty, you have no right to claim right. These are the various aspects, dear friend. I have given this entire summary today, and in 2 days back I uploaded this in Telugu, and now I am in English. Please note that all are in English. So I thank you very much, dear friends, for having extend your help and support in reaching my channel to 22,300 subscribers. At the same time, I request you, don't unsubscribe my channel after the completion of your final BL. My channel has some peculiarity. After studies are over, students are unsubscribing it. Please treat me as your teacher, and remember me. If you keep the subscription unsubscribed, so you can know. Whereas and when my notification is there, you can see my face, then you think that Raga Surya Aru is okay, he is active. You can have the inspiration. For that inspiration, I request you, join me to share our service to many more by sharing my channel to many more of your near and dear friends. Thank you very much for your patient hearing. I am giving lengthy lectures because if I give it in part wise, it will be split. You read one part. Now it is in one bundle, one video, half an hour, or you watch it. Thereafter you watch after half an hour, like that. Little you can continue the same video. If it is split into so many videos, the position will be diverted. That is another thing, friends. There are more than 280 videos. Students are confusion. That video is there or this video is there or not. What I tell you, either you type or say, touch YouTube mic, and say Raga Surya Rao video lectures. 2. Subject name. 3. Chapter name. Raga Surya Rao video lectures, transfer of property, gift. Raga Surya Rao video lectures, transfer of property, mortgage. Raga Surya Rao video lectures, constitutional law 1, summary, article 1 to 51A. If you call like this or type like this, you will get my video. Whatever subject you want, you say my name or type my name first, subject name next, chapter name next. If I have uploaded that particular lecture, you will get it immediately. Along with me, some other videos also uploaded by some other teacher friends will come. If my video is not uplifted, you will get the video of some other teachers, so that you can serve the purpose. So that is why don't say that where is that video, like that. So many friends are asking, even though the videos are done, they are telling, please upload video. That subject was totally uploaded. So please make use of my lectures and help me to serve you, join you join me to do service to many more. I don't need any benefit. If little any, if you have unlimited net or Wi-Fi, you watch it. If you have limited data, you download it, share among your friends. Same if any little income is generated, it can be given to some poor people or the temples in poor condition. But what I get from this is very little. What I add and give it is much. So what I get maybe 10%, I may add 80 to 90% and give. So it's just a little. You can help me. Thank you very much. Thank you very much for reaching my channel to 22,300 and above. Unfortunately, I cannot speak Hindi. In case I would able to speak Hindi fluently, the channel will be at least to 20 lakhs. 20 lakhs. I am given to understand that lakhs of students are making use of my channel. Many more are getting benefit, because in majority of the institutions of legal studies, teachers are very number of teachers are very limited. 10 to 20 teachers are required, 2 to 3 teachers are appointed. The situation in many colleges and university department. Thank you very much for your patient hearing. Thanks a lot.